Hi, I'm making this video to share the fourth and the last egregious ruling by the Hearing Officer Angela Gupta. So, some states explicitly ban any communications about non logistical issues between the hearing officer and the State Department of Education, and they require communications about logistical issues to be disclosed to all the parties involved. So, if you are watching this video and if you are from one of those states, please comment on this video and share your knowledge or experiences or share a link to the regulations of your state. So, in those states, if the hearing officer has to communicate about the logistical issue with the State Department of Education, he or she discloses the communication to both the parents and the school district. And by no means the hearing officer communicates with the State Department of Education about a non-logistical issue. Unfortunately, Kansas doesn't have this type of regulations that govern communications between hearing officers and the State Department of Education. So at one point, we came to believe that Angela Gupta had been communicating with the Kansas State Department of Education (KSDE) about the merits of our case. More specifically, we came to believe that Blue Valley was communicating with Angela Gupta through KSDE. There were so many signs of that. And on October 7, we filed a motion for disqualification, saying that we believed there had been communications between KSDE and Angela Gupta about our case, and because of that, we asked Angela Gupta to recuse herself from the proceeding. We also requested Angela Gupta in the same motion to disclose all the future communications between her and KSDE in case she didn't recuse herself from the proceeding, in case she refused to recuse herself, because we can't make her recuse herself. Angela Gupta, in her response, refused to both recuse herself and disclose her future communications with KSDE. So she did admit communicating with KSDE about our case, but she said those communications didn't concern the merits of the case. And as for her future communications with KSDE, she said that, quote, petitioners haven't presented circumstances requiring the undersigned to disqualify herself from serving as hearing officer and or report the details of every past or future communication with KSDE relating to this due process proceeding, quote. So she was basically saying that you don't have evidence to prove your accusation, so I can do whatever I want unless you catch me, which you can't. So I don't need to be transparent as long as I'm not caught. Otherwise, she could have said, see, here are my previous communications with KSD, you got it all wrong, you have nothing to worry about. Or she could have said, what's done is done, but from now on, I'll disclose all my future communications so there won't be any loose ends after the case is closed, and everybody will have closure after this case is concluded. But no, she doesn't say any of that. Quite the opposite. She leaves a lot of loose ends. She says, I do communicate with KSD, and that's none of your business. And so she chose to be less transparent, not more, in the face of questions, suspicions, and accusations. And that, of course, only served to heighten our conviction that she was indeed receiving instructions from KSDE. So Blue Valley was communicating with her through KSDE. KSDE was like the middleman in our case. And like she said, of course, we can't prove, we don't have any direct evidence of that. How can we obtain evidence showing that? We can't question and interrogate Angela Gupta or Krista Greenwood or Blue Valley's lawyers We don't have access to their emails. We don't have access to their call logs or whatever. Of course, we can't prove. Anyways, soon after, on October 18, so that's 2 days after she dismissed our second due process complaint with prejudice, Angela Gupta ordered us to respond by October 22, stating whether we intend to move forward with our due process complaint, with our first due process complaint. So her order stated that, quote, the failure to respond by October 22 may result in the dismissal of the problems/claims asserted in the initial complaint with prejudice, without further notice to the parties. So it was like the Tisch-Taylor order, show cause why I shouldn't quash the subpoena, and this time she was saying, show cause why I shouldn't dismiss your complaint. And she had dismissed our second due process complaint already a few days ago. And she gave us 4 days to make up our minds, October 18, October 22. So 4 calendar days, but you can check it in your calendar. It's actually 2 business days because October 18 was a Friday. So she did something similar in the Tisch-Taylor case. She gave us 5 calendar days, but actually 3 business days to show cause why the subpoena shouldn't be quashed. So this is against the rules she herself made, Angela Gupta made early on in the proceeding. Back in June, she issued an order giving the parties 5 business days to respond to motions. So when Blue Valley filed a motion, we had 5 business days to respond to their motion. And when we filed a motion, Blue Valley had 5 business days to respond to our motion. 5 business days for the motion to bifurcate, clarify issues. And what's the rush now? 2 business days. We have to make critical decisions in 2 business days. They dragged out the case for several months. We filed a due process complaint on May 9, early May. Hardly anything was done in May and June. There was no progress. There was actually a regression because the most important part of our complaint was dismissed in July. So why rush us now to make critical decisions in 2 business days, 3 business days? And in her order, Angela Gupta tell me why I shouldn't dismiss your complaint order effectively forced us to make a choice among 3 options. Okay, so she gave us 3 options to choose from. First, we go through an unfair hearing. It's clear now. At that point, it was clear. The hearing won't be fair. Okay, and so we go through that. We go through an unfair hearing meant for covering up for Blue Valley and KSDE. Second option, we voluntarily dismiss our complaint by the deadline. By the deadline, she said, October 22. Or Angela Gupta dismisses our due process complaint with prejudice after the deadline. So we went for the second option and filed a motion to voluntarily dismiss our complaint on October 21. So 1 day before deadline. So we thought we could at least avoid a dismissal with prejudice and we can bring up the complaint again somehow. Still, Angela Gupta ordered a dismissal with prejudice on October 22. So less than a week after she dismissed our second due process complaint with prejudice. So we got 2 complaints dismissed with prejudice in less than a week. And she gave us 3 options. So basically, we were given a carrot and a stick to choose from. And we went for the carrot, but still she gave us the stick. Yeah, so this is how she informed us about the dismissal on October 22. Just an email with the PDF file attached. Very short. And this is Krista Greenwood's response. Again, very short, very brief. Doesn't mention anything about our right to appeal, how can we appeal, how we can, if we can appeal, if the ruling is appealable even. Quite the opposite. She's basically everybody is giving us the impression that the case is closed and that's it. There will be no appeals. So if you have any additional issues, you will need to file another due process complaint. But this case is closed permanently. And that was it. But the statute says written notice of the result of any hearing provided for under this act shall be given to the agency providing for the hearing and shall be sent by certified mail to the parent or return of the child within 24 hours after the result is determined. And as I said in my previous video, actually these mailed rulings, decisions have like a right to appeal notice at the end. We never received anything in the mail. So all we received was what I just showed you. Just Angela Gupta's email with the PDF attached and Krista Grum's reaction to it. And everybody was leading us to believe the case was closed forever. And that was it. So we couldn't appeal to the decision. We lost our chance to take the case up to the federal court. These rulings really prejudiced our case, irrevocably hurt our case. So to summarize, Angela Gupta, Blue Valley, and KSDE together engineered this outcome, this dismissal with prejudice, by bullying and gaslighting us over several months, by wearing us down, and eventually by manipulating us into giving up, by using a carrot and stick approach at the end. So we are now suing Angela Gupta. We have an ongoing case in the federal court. And you know who represents her? Who is her lawyer? She is represented by KSD's lawyers in the lawsuit, which is a waste of taxpayers' money. She could have got her own lawyer. And these people, KSD's lawyers, they don't represent ordinary individuals. They represent large institutions like KSDE. And this alone shows that hearing officers like Angela Gupta aren't independent of KSDE. They are not impartial, but they are just extensions of KSDE. It also proves the point we made when we tried to disqualify Angela Gupta. She did communicate with KSDE about our case, and KSDE now wants to cover it up, wants to keep it in the family. But they can't cover it up any longer. The truth will come to light, and the truth will ultimately prevail. Just because they have the power doesn't mean they have the right.